Welcome to the Appendix, where we read the primary sources of the past so the present can be better understood. Today's primary source, Fletcher V Peck, 1810. Heir to the U.S. Circuit Court of the District of Massachusetts. In 1795, the legislature of Georgia passed an act for the sale of erroneous areas of her western lands. The following year, a new legislature annulled the act of 1795 on the grounds that it passed fraudulently. The celebrated case of Fletcher V Peck involved two major constitutional questions: the interpretation of the contract clause of the federal constitution and the power of the court to inquire into the motives and circumstances attending the passage of a legislative act. This was the first case in which the Supreme Court held a state law void under the Constitution. Marshall, Chief Justice, that the legislature of Georgia, unless restrained by its own constitution, possesses the power of disposing of the unapproved lands within its own limits in manner as its own judgment shall dictate, is a proposition not to be controverted. The only question, then, presented by this demurrer for the consideration of the court is this: did the then Constitution of the state of Georgia prohibit the legislature to dispose of the lands which were the subject of this contract in the manner stipulated by the contract? In the Constitution of Georgia, adopted in the year 1789, the court can perceive no restriction on the legislative power which inhibits the passage of the Act of 1795. The court cannot say that, in passing that act, the legislature has transcended its powers and violated the Constitution. In overruling the demurrer, therefore, to the first plea, the Circuit Court committed no error. That corruption should find its way into the governments of our infant republics and contaminate the very source of legislation, or that impure motives shall contribute to the passage of a law or the formation of a legislative contract, are circumstances most deeply to be deplored. How far a court of justice would, in any case, be competent, on proceedings instituted by the state itself, to vacate a contract thus formed and to annul rights acquired under that contract by third persons having no notice of the improper means by which it was obtained, is a question which the court would approach with much circumspection. It may well be doubted how far the validity of a law depends upon the motives of its framers, and how far the particular inducements operating on members the supreme sovereign power of a state to the formation of a contract by the power are examinable in a court of justice. If the principles be conceded that an act of the supreme sovereign power might be declared null by a court in consequence of the means which procured it, still would there be much difficulty in saying to what extent those means must be applied to produce this effect. Must it be direct corruption, or would interest or undue influence of any kind be sufficient? Must the vitiating cause operate on a majority, or on what number of members? Would the act be null, whatever might be the wish of the nation, or would its obligation or nullity depend upon the public sentiment? If the majority of the legislature be corrupted, it may well be doubted whether it be within the province of the judiciary to control their conduct, and if less than a majority act from impure motives, the principle by which judicial interference would be regulated is not clearly discerned. Whatever difficulties this subject might present, when viewed under aspects of which it might be susceptible, this court can perceive none in the particular pleadings now under consideration. The case, as made out in the pleadings, is simply this: one individual who holds lands in the state of Georgia under a deed, coveting that the title of Georgia was in the grantor, brings an action of covenant upon this deed, and assigns as a breach that some of the members of the legislature were induced to vote in favor of the law which constituted the contract by being promised an interest in it, and that therefore the act is a mere nullity. This solemn question cannot be brought thus collaterally and incidentally before the court. It would be indecent in the extreme upon a private contract between two individuals to enter into an inquiry respecting the corruption of the sovereign power of a state. If the title be plainly deduced from a legislative act which the legislator might constitutionally pass, if the act be clothed with all requisite forms of a law, a court, sitting as a court of law, cannot sustain a suit brought by one individual against another, founded on the allegation that the act is a nullity in consequence of the impure motives which influence certain members of the legislature which passed the law. It is not intended to speak with disrespect of the legislature of Georgia or of its acts. Far from it. The question is a general question and is treated as one. For although such powerful objects to a legislature grant as are aligned against this may not again exist, yet the principle on which alone this rescinding act is to be supported may be applied to every case to which it shall be the will of any legislature to apply. The principle is this, that a legislature may, by its own act, divest the vested estate of any man whatever for reasons which shall by itself be deemed sufficient. In this case, the legislature may have had ample proof that the original grant was obtained by practices which can never be too much reprobated, and which would have justified its abrogation so far as respected those to whom crime was imputable. But the grant, when issued, conveyed an estate in fee simple to the guarantees, clothed with all the solemnities which law can bestow. This estate was transferable, and those who purchased parts of it were not stained by that guilt which infected the original transaction. Is the power of the legislature competent to the annihilation of such title and to a resumption of the property thus held? The principle asserted is that one legislator is competent to repeal any act which a former legislator was compelled to pass, and that one legislature cannot abridge the powers of a succeeding legislator. The correctness of this principle, so far as respects general litigation, can never be controverted. But if an act be done under a law, a succeeding legislature cannot undo it. The past cannot be recalled by the most absolute power. Conveyances have been made. Those conveyances have vested legal estates, and if those estates may be seized by the sovereign authority, still that they originally vested is a fact, and cannot cease to be a fact. When then a law is in its nature a contract, when absolute rights have vested under that contract, a repeal of the law cannot divest those rights, and the act of annulling them, if legitimate, is rendered so by a power applicable to the case of every individual in the community. It may well be doubted whether the nature of society and of the government does not prescribe some limits to the legislative power, and if any be prescribed, where are they to be found? If the property of an individual, fairly and honestly acquired, may be seized without compensation. To the legislature all legislative power is granted, but the question whether the act of transferring the property of an individual to the public be in the nature of legislative power is well worthy of serious reflection. The validity of this rescinding act then might well be doubted, were Georgia a single sovereign power. But Georgia cannot be viewed as a single unconnected sovereign power, on whose legislature no other restrictions are imposed than may be found in its own constitution. She is part of a large empire. She is a member of the American Union, and that union has a constitution, the supremacy of which all acknowledges, and which imposes limits to the legislatures of the several states, which none claim a right to pass. The Constitution of the United States declares that no state shall pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts. Does this case now under consideration come within the prohibitory section of the Constitution? In considering this very interesting question, we immediately ask ourselves, what is a contract? Is a grant a contract? A contract is a compact between two or more parties, and is either executionary or executed. An executionary contract is one in which a party binds himself to do or not to do a particular thing. Such was the law under which the conveyance was made by the government. A contract executed is one in which the object of the contract is performed, and this, says Blackstone, differs in nothing from a grant. The contract between Georgia and the purchasers was executed by the grant. A contract executed, as well as one executionary, contains obligations binding on the parties. A grant in its own nature amounts to an extinguishment of the right of the grantor, and implies a contract not to reassert that right. A party is, therefore, always estopped by his own grant. Since, then, the fact a grant is a contract executed, the obligation of which still continues, and since the Constitution uses the general terms contracts without distinguishing between those which are executory and those which are executed, it must be construed to comprehend the latter as well as the former. A law annulling conveyances between individuals and declaring that the grantors should stand seized of their former estates, notwithstanding those grants, would be as repugnant to the Constitution as a law discharging the vendors of property from the obligation of executing their contracts by conveyances. It would be strange if a contract to convey was secured by the Constitution, while an absolute conveyance remained unprotected. If, under a fair construction of the Constitution, grants are comprehended under the terms contracts, is a grant from the state excluded from the operation of the provisions? Is the clause to be considered as inhibiting the state from impairing the obligations of contracts between two individuals, but as excluding from the inhibition contracts made with itself? The words themselves contain no such distinction. They are general and are applicable to the contracts of every description. If contracts made with the state are to be exempted from their operations, the exception must arise from the character of the contracting party, not from the words which are employed. It is then the unanimous opinion of the court that in this case, the estate having passed in the hands of a purchaser for a valuable consideration, without notice, the state of Georgia was restrained either by general principles which are common to our free institutions, or by the particular provisions of the Constitution of the United States, from passing a law whereby the estate of the plaintiff in the premises so purchased could be constitutionally and legally impaired and rendered null and void. Judgment affirmed. Thank you for joining us for our primary source today on the appendix. We will see you in the stacks.